Hello, and welcome to a special episode of Illinois LawCast, a podcast about the wisdom, wit, and curiosity of the University of Illinois College of Law. I'm your host, Chris Davies, and this episode is all about Trump versus Barbara, the case heard on April 1st by the Supreme Court regarding birthright citizenship in the United States. My guest is Professor Jason Mazzone, an expert in constitutional law and history who has done extensive scholarship and writing in this area and been quoted in many outlets, such as the Chicago Tribune and New York Times, about birthright citizenship as it is written in the 14th Amendment. Professor Mazzone joined me for the special bonus episode to lay out the facts of the case, discuss what he heard from arguments at the Supreme Court, and share his opinion on how the case might be decided. Professor Mazzone, thank you very much for joining me today.
Thanks for having me. It's a pleasure to be here.
Yeah, we're here to talk about Trump v. Barbara, on which you have written extensively and been quoted. And I want to start kind of at the beginning. How did this come to the Supreme Court, and why did it make it to that level?
Sure. So when President Trump took office, was sworn in January of last year, one of the very first things that he did was to issue an executive order that purports to limit birthright citizenship to children who are born in the United States and who have at least one parent who is a U.S. citizen or a U.S. permanent resident. And so a child born in the United States whose parents are here in temporary capacity because maybe they're working or they're students studying or they're tourists, and parents who are in the country unlawfully, those children under the executive order are not eligible for citizenship of the United States at birth. The executive order was immediately challenged on two grounds, one of which has gotten a lot of attention, the other which I think may turn out to be a bit more important in terms of how things actually end up. But the main focus of the challenge is the 14th Amendment of the Constitution. And so I did bring, the text of the Constitution with me. I always carried it around to make sure we get the language right. So the 14th Amendment says, Section 1's opening words, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So if you match the language of the executive order onto the language, the text of the 14th Amendment, there seems to be a clear contradiction.
Yeah.
The 14th Amendment confers citizenship at birth on children, babies who are born in the United States, subject to the jurisdiction. We talk a little bit about what that means, but it says nothing about parents and the status of parents. It doesn't say born to parents who are permanently in the United States, or born to parents who are United States citizens, or born to parents who are lawfully in the country. None of that is in that provision of the Constitution. This 14th Amendment, Section 1, is really the crown jewel of the Reconstruction amendments. It overturns a decision by the U.S. Supreme Court in 1857 called Dred Scott, in which the court, in an opinion by Chief Justice Taney, had held that under the Constitution, no black person could ever be a citizen of the United States, even if born in the United States. The 14th Amendment overturns that in its very first sentence, but it's clearly not limited to the context of children of former slaves. It's not limited to any particular racial group. It is written in very general language. And the Trump order just appears to simply defy the plain text of the 14th Amendment, not just the plain text of the 14th Amendment, but the way in which the 14th Amendment has always been understood from the time of its ratification in 1868. I said the 14th Amendment issue is the question that has gotten the most play and the most press, but there's also a separate basis on which the Trump order has been challenged in the courts, and that is under federal statutory law. And so Congress has enacted a statute called the Immigration and Nationality Act of 1952, in which it provided specifically in that statute that citizens of the United States are children who are born in the United States and subject to the jurisdiction. So it's tracking the 14th Amendment language. The Trump order also defies that statutory provision. Presidents don't have an ability to ignore what Congress has said. And so sort of the other piece of the challenge, besides the pure constitutional claim, is that this executive order just flouts a valid federal statute in place since 1952, and that has been understood since that time without any sort of dissent or departing views as conferring citizenship on children born in the United States without regard to the status of their parents, with some narrow exceptions. The narrow exceptions, and they do track the language of the 14th Amendment, subject to the jurisdiction of the United States, has always, with rare exception, been understood to mean subject to American law. That if you're in the country and you are governed by ordinary laws of the United States, then that requirement of the 14th Amendment is satisfied. There are three groups that have been understood consistently since the time of ratification of the 14th Amendment as not subject to the jurisdiction of the United States. Three narrow groups. One, if you're talking about children born to diplomats, and the classic case would be you're born in an embassy. You are within the United States, but an embassy is essentially foreign soil. You're not subject to the laws of the United States in that context. Second exception is born on a Native American reservation. Those operate independent of federal law. And so if you're born in that context, then you are not a citizen at birth under the Constitution. And then the third context is one that just hasn't come up, which is if you're born behind enemy lines. So if the situation were to arise where, say, Canada invades the United States and occupies some portion of the country, and you are a trader and you're born in Canadian occupied territory, also not subject to the normal operation of American law, and so would not be a citizen at birth. Those are the three exceptions, the sorts of exceptions that the Trump executive order would add go well beyond the plain language of the 14th Amendment and well beyond what Congress said in 1952. So the challenges were brought, of course, in the lower courts. Every single court that heard a challenge to the Trump executive order held at a preliminary stage of the litigation, blocked the order as inconsistent with the 14th Amendment and with the federal statute. So the government's claim that the order properly reflected some understanding of the 14th Amendment or of the statute of 1952 was rejected by every judge. Republican-appointed judges, Democratic-appointed judges, courts in different parts of the country. The government, not surprisingly, took the case to the Supreme Court, and that is the case then, it's called, as you said, Trump versus Barber, on which the Supreme Court heard oral argument last Wednesday, in which the administration is asking the Supreme Court to overturn what the lower courts had held and to adopt its understanding of the 14th Amendment. Let me just say something very quickly about what the government's argument is and how any of this even gets any sort of traction. The government says the thing that it is focusing on in the 14th Amendment is this language subject to the jurisdiction thereof. And its argument is that this should not be understood to mean that you're subject to, governed by U.S. law, but that this language has a sort of special technical meaning that requires that if you were born in the United States, that you also be born to parents who have an allegiance to the country. And the government says somebody who's here in a temporary capacity, somebody who has violated U.S. law and is in the country illegally, those people don't have allegiance to the United States. They have allegiance to some foreign country. And so the 14th Amendment birthright citizenship provision should not apply to their children. Two big problems. Again, you're talking about parents, and the government's argument is based on the allegiance of the parents. 14th Amendment says nothing about parents, and neither does the statute. Second big problem is that the government's understanding of subject to the jurisdiction of the United States as being about individual allegiance and loyalty to the country is just an extraordinarily eccentric reading of words that have a much more straightforward, long-supported understanding as being subject to American law.
So that was a little bit of what Solicitor General Sauer was presenting to the court. What else was part of that argument and the other side coming from the ACLU's representative that the judges heard?
On the ACLU side, so Cecilia Wong represented the challengers in the case. And I think, she had the easier side of the argument because she has text on her side. She has a long history of how that text has been understood and implemented and applied. She had also a Supreme Court case from 1898 called United States versus Wong Kim Ark, in which the Supreme Court adopted the view of the 14th Amendment that I had described as the most plausible reading of the 14th Amendment. That case involved parents who were Chinese nationals who were in the United States. They were not U.S. citizens. They give birth to a child. The government wants to reject the claim of citizenship under the 14th Amendment. And the court writes a very clear opinion in which it says, no, the text means what it says, and doesn't say anything about the status of the parents, whether they were U.S. citizens or not. Born in the United States, subject to American law, makes you a citizen of the United States. And so the ACLU has a Supreme Court case on point that I think in order for the Trump administration to prevail, the Supreme Court would have to overturn. It's generally reluctant to overturn cases. And so that's a real uphill battle for the Solicitor General. The court, the justices, as they always are in oral argument, were very prepared, very engaged. They had a lot of questions. They had questions for both sides because they're very interested in history and historical meaning, questions for both sides about how these words were understood when added to the Constitution in 1868, how the 14th Amendment was implemented after 1868. The Solicitor General pointed to some statements in certain sources that suggested that maybe birthright citizenship should not be understood in the way that the plain text would suggest. These tended to be fairly isolated, I would say cherry-picked statements, not supportive of the general public understanding at the time, which is what the court is very interested in. So that many of the arguments of the Solicitor General pursued his arguments about text and history. Surprisingly, the Solicitor General also made a whole series of policy-related arguments. And so one thing that he said, for example, was that the United States, if you accept the argument by the ACLU, would be one of just a few countries around the world, is I think actually about 30, that allow for birthright citizenship. It's an interesting argument because members on the more conservative side of the court shot back and said, but our job is to interpret the U.S. Constitution. It's not to look to what other countries are doing. That was noteworthy to me because ordinarily arguments for looking to practices in other countries and how other courts in other places are understanding their constitutions are usually arguments brought by litigants who are interested in more progressive readings of the Constitution. The more progressive reading here, the one that the ACLU wants, is one that would say, don't pay any attention to what is happening in, say, Germany or France or other places. The Solicitor General also made quite central to his argument the problem of what he called birth tourism. And so This is one of the apparent reasons that the administration has adopted this executive order to shut off the possibility of non-U.S. citizens, principally from China and India, traveling to the United States as tourists, giving birth to a child who would then, if the ACLU is right, would have U.S. citizenship. And then down the road, they actually have to wait until they're 21, sponsor a parent as a permanent resident. And the Solicitor General hammered this point. Chief Justice Roberts, in response to that, said, well, was that a problem in 1868 when the 14th Amendment was ratified? And the answer is, of course, no, there was no such thing. The Solicitor General said, but we live in a new world. And Roberts shot back, it might be a new world, but it's an old constitution. Yeah. And again, it was an interesting exchange because there are people who think that we should have a more living constitution, that in understanding the constitution, it should be updated in light of modern problems and modern circumstances. If you were to follow that logic, which is being put forth by the Solicitor General, it would limit the scope of the 14th Amendment. So the ACLU position is, no, actually, you want to think about what it meant in 1868. So there's a sort of interesting dynamic in terms of who was saying what.
Right, because that's more originalist, which would tend to be the conservative side.
It's and it is the originalist argument that dooms the executive order. The plain meaning of the 14th Amendment at the time it was ratified renders unconstitutional the executive order. The plain meaning, public understanding of the 1952 statute at the time that it is enacted dooms the executive order. So it's a good lesson because, many people think, originalism is always going to produce kind of conservative approaches, but it's not true. And I think this is one instance. If the court ends up deciding the case on 14th Amendment grounds, I expect you'll get a strongly originalist opinion for why the Trump order is invalid.
And you said that it really dooms this. I'm wondering if you could give your opinion about how you think that this might be decided when they do hand that down in June or July.
Yeah, I think probably July. I think this will take a little while. So as I said at the outset, there's sort of two pieces to this. One is the big 14th Amendment issue. The other is this 1952 statute. I think the outcome of the case is not in doubt. The executive order will be invalidated. And I think by a very lopsided margin, 8-1-9-0. So I think the outcome is not in doubt in terms of the fate of the executive order. I think the outstanding question is whether the court goes big and decides the issue on 14th Amendment grounds, or if it decides the issue on the basis of a conflict between the executive order and the federal statute. Now, courts generally prefer to resolve issues on statutory grounds, if they can, not reach constitutional issues unless they really have to. And there's a very straightforward basis on which the Supreme Court could hold that the 1952 statute, what Congress had adopted at that time, simply bars the limitations in the executive order, and that would be that there would be no particular reason to then go on and ask about the constitutional question. My hunch is that that is probably going to ultimately be the basis for the decision, that the majority, and I think it will be a lopsided majority, will coalesce around a statutory holding. I expect also, though, that some members of the court will say it's important to write about the constitutional question as well. So I see this thing going down. Again, maybe 9-0. I think what will unite at least 5 members of the court will be that it's invalid under the statute. And you'll have some members of the court who will want to address the 14th Amendment issue as well. The one limit to a statutory holding is that Congress could change the statute. And so if that were the basis on which the court invalidates the executive order, there's some conceivable scenario in which the president could go to Congress and say, alter the statute. And then that would, I think, bring the 14th Amendment back to the Supreme Court. So that issue might be left for the future. I think politically, the chances of all of that happening are probably low. And I think even though, I would love to see a strongly worded decision on the 14th Amendment rationale, that a statutory holding can be written in a way that accomplishes essentially the same result.
Great. Professor Mazzone, thank you very much for your time. I appreciate you sitting here and explaining that in such an accessible way.
Thank you. Anytime. I appreciate it.
Thank you once again to Professor Jason Mazzone for sharing his expertise. If you'd like to read more, he is extensively quoted in the New York Times on this case, and that article is linked in the show notes. Thank you for listening to this bonus episode of Illinois LawCast. We will be back with our regular April episode later this month.